Okay, good morning. I'm going to call this session of the Kenmore Hearing Examiner to order, January 13, 2016. I'm Ted Hunter, who's the hearing officer that's been chosen by the city to hear and decide certain matters that are appealed to the hearing examiner. Today, we have an appeal that's been filed by Gish, Long Life Retreat and Healing. It's an appeal of the city's denial of the renewal of a business license for that business. I believe the appellant is represented by legal counsel here. Good morning to you. Would you please introduce yourselves? Who are each of you?
I'm Farah Dawn. That's F as in Frank, A-R-A-D as in David, A-U-N, with Tollefson Law.
Okay.
And I am Matthew Van Ziepel. It's V-A-N-Z-E-I-P-E-L, also with Tollefson Law.
Very good. We have two attorneys then present for the appellant, and for the city we have...
Yes, my name is Chris, C-H-R-I-S, Kang, K-A-N-G, representing the city of Kenmore.
Very good. This appeal is quite simply stated as whether the appellant violated specific sections of the Kenmore Municipal Code, such as the city properly denied the renewal. To help prepare for the hearing, I issued in advance of the hearing today a pre-hearing order asked that each attorney identify any witnesses and documents they expected to present today. And each of you has complied with that. I have in front of me in this notebook the documents that you provided, and I believe each of you identified one witness to call today. The procedure that we follow with documents is that when submitted in advance of the hearing, they're deemed admitted unless there's an objection raised either prior to the hearing or during the course of the hearing. I need not adhere strictly to the rules of evidence. The city legislative authority has granted me some discretion in what evidence I receive, so I use a rule of reason, but I do entertain objections and will rule on objections if presented either at this time or during the course of the hearing. Are there any objections of any documents that were submitted in advance of the hearing?
We have, we may have an objection to document number.
This is Farah Dawn, attorney for the appellant. One of the city's documents.
Yes.
Well, if you may have it, you're not making it now. So we will wait until it may be presented during the course of the hearing, and at that time you'll have another opportunity to object to the evidence being presented by the city.
And, Your Honor, if I may interject, we have two witnesses actually we'll be calling. We listed them as well, Chief Souther and Deputy Durant of the King County Sheriff's Office. We also have objections to the appellant's materials. They are numbered A6 and A7. These are testimonials of David Talent and Patty Sturgis. Our objection rests on the fact that they are not under oath. They're not in the form of a proper declaration pursuant to RCW 9A. They're not listed as a witness either. We have no way to provide or cross-examine these witnesses as well. So we object on those premises.
Okay. Appellant's counsel have any response to the city's objection to two documents you submitted, A6 and A7?
The documents were submitted primarily for purposes of mitigation and character. We were unable to bring the witnesses here today. But we think the documents stand on their own.
for purpose of character and mitigation, but not related to the alleged violation.
Right.
Okay. I'm not going to refer to them. The question of character is not here before me today. It's only focused on the alleged violations of the code. So those documents are not necessary, nor would they be considered in my decision. Okay, anything further before we begin? Any other preliminary matters?
No, Your Honor.
No, Your Honor.
All right, then the course that we will follow, as outlined in my pre-hearing order, is to allow the city to present its evidence first. The appellant may cross-examine the two witnesses, forgive my earlier oversight, and then we'll allow the appellant to respond as they choose to do so. This proceeding is being recorded. It's what's known as an open record hearing. It is the one opportunity to present evidence. If there's an appeal, it's based only on the record created in this hearing room today, which would consist of the documents that have been submitted and any transcription of testimony presented. We ask that you present testimony at this chair, the witness chair, to my right, and when you do so, please take the oath before you present testimony that I will administer to you. Mr. Kang, we're ready to hear the city's presentation.
Yes, Your Honor. The City of Kenmore calls Deputy Jeffrey Durant to the stand.
Good morning, sir. And do you swear to tell truth and testimony you give today?
I do.
Thank you.
Good morning, Deputy Durant.
Morning.
Please identify your name for the record.
Jeffrey Durant versus Jeffrey. Last is spelled Durrant.
Thank you. And what is your current occupation?
I'm a King County Sheriff's Deputy, police officer assigned to the City of Kenmore.
Okay. And how long have you been in the force?
16 years.
Okay. And what sort of training did you receive to become a deputy sheriff?
First the academy, state academy, 740-hour academy, I believe, and then continuing education throughout my career.
Okay.
Classes, investigative classes.
Okay.
Enforcement specific.
And in your job, do you perform investigations on businesses requesting license renewals?
I do.
And then how many of such investigations have you performed?
Roughly a dozen.
Okay, great. And have you met the appellant Gish before?
Yes, I have.
Okay. And how or when did you meet her?
It was November or something. I met her previously, roughly a year ago, on my first stop at her business for license renewal, and then again, I think it was November or December. I believe, I can't remember exactly when it was.
November 19th?
But yes,
Okay.
sounds right.
All right. And
May I refer to my case report I have in front of me? Is that okay?
I have no
Objection to
problem
that?
with that.
No
Referring
objection.
to notes for recollection.
great. And on November 19th, when you visited, was that part of your routine investigation?
Yes, it was.
Okay. All right. Before we dive any further into it, I just wanted to discuss the incident report and your declaration that's in the materials. Did you write the incident report about your investigation on November 19th, 2015?
I did, yes.
And when did you submit that report?
It would have been that day, possibly the next day.
Okay.
Mr. King, what document are we referring to?
Oh, I'm sorry. We are referring to the document number C3, City's Exhibit C3. That is the King County Sheriff's Department's incident report, which is also incorporated as part of the declaration of Jeffrey Durant in C2.
Thank you.
The purpose right now is to lay the foundation for the two documents. If I may, if there's no objections, I can skip over that part and deem those items admitted. And
Well, I'll restate what I said at the outset of this hearing. It is the course of conduct in these proceedings that the documents submitted in advance of the hearing are deemed admitted unless I hear an objection during the course of the hearing.
Okay.
So these documents have been admitted you need not go through any formal identification, submittal, and ruling. Does that help?
That helps. Thank you, Your Honor.
Good. I hope I'm clear on that.
Okay. All right.
Please proceed.
Thank you. Let's go to the incident on November 19th, 2015. Why did you go to Ms. Gish's massage business that day?
For a general inspection for renewal of her license,
Okay.
business license.
Okay. And when you first walked in, what did you see?
I walked in, I was greeted by Miss Gish. She was at the front desk.
Okay.
We spoke briefly. I told her I was there to do an inspection for business license renewal. What we're looking for is up-to-date business license posted. Her license to practice massage therapy was posted. That the fee schedule is posted. Then we continue on with the business. And as we're talking, she told me there was somebody getting a massage in the back room. That time the door opened and an Asian female and a male walked out. The male came down the hall and passed me, and I called out to the Asian female. She looked at me, looked kind of surprised, made eye contact with Miss Gish, and she turned around and went to the back room.
Okay. Did you see any other person's massage practitioner license posted?
No, the only one that I found was Miss Gish's license to practice massage.
Okay. Did you speak with Ms. Gish about whether someone else was providing massage that day?
Yeah, very briefly, I asked who she was, and Miss Gish said, oh, she's just helping me out, and that Miss Gish said that she had been training her to do massage. I inquired whether or not she was a licensed massage therapist, and she said, well, I've been training her myself.
Okay.
At that point, I went to the back room to find the other lady.
Okay. And Ms. Gish admitted that the person providing the massage was not licensed?
Correct.
Okay. And is that, to your knowledge, is that allowed?
No, that's a violation of the licensure for the business.
All right. And during this conversation, what was your observation of Ms. Gish?
She was pretty surprised and taken aback that I was there,
Okay.
and she was obviously very nervous.
Okay. And you indicated that the gentleman walked towards the front.
Correct. He and I pretty much, he passed me
Okay.
right in the hallway waiting area.
Okay. And why did you think he went to the front?
I assumed to pay for services and exit the business.
Okay. And then when the Asian woman, you later identified as Miss Lin,
Correct.
did you proceed to the back room to speak with her?
I did.
Okay.
I went to the back room, checked what was I presume a break room, checked the men's bathroom, didn't look at the women's bathroom.
Okay.
There was another back stock room back there. I looked back there, and she was nowhere to be found. I did knock on the women's bathroom, and there was no answer.
Mm-hmm. Did you eventually find her?
Yes, we ended up. I was in the back room for a minute or two. Miss Gish joined me back there. We ended up finding her. She had exited the back of the building and down 2 flights of stairs on the stairwell.
Okay.
It was in the back parking lot.
Okay. In your opinion, what did it look like Miss Lin was doing?
She was trying to leave the area.
Okay. And did Miss Gish join you during this time?
Yes, it was about a minute or two later after I'd gone to the back room looking for her.
Okay.
Miss Gish and I found the woman in the back,
Okay.
down in the back parking lot.
And then did you speak with Miss Lin?
I did. Yes, she came up and we all met up in the front lobby area.
Okay.
I asked for her identification. She produced, I think it was California ID, identifying her as Miss Lin.
Okay.
And she produced a California State massage therapist license, ID card. She admitted she was not licensed in Washington,
Mm-hmm.
and that she was up here to work, but
Okay.
she had not had time to get her licensure yet, her license to massage
Okay.
in Washington.
All right. And did you speak with Miss Gish after this, after your conversation with Miss Lin?
Yes.
Okay. And what did you discuss with her?
Just that Miss Lin wasn't authorized to practice massage here, and she was in violation, that I would be writing a report stating such
Okay.
and sending it to City Hall for the review.
And just to clarify that you mentioned that Ms. Gish told you that she trained Ms. Lin? Is
Correct.
that correct? Okay.
Mhm.
All right. And did you also observe Ms. Gish walking and moving around that day?
Yes, I did.
Okay. Did you notice any, excuse me?
Objection.
What?
It's irrelevant.
What's irrelevant? What are you objecting to?
This, where this line of questioning is going.
I'm sorry, I'm not following. What is the question that you objected to?
The characterization of how Ms. Ms. Gish was walking around.
Okay, can we just move past that?
Well,
It's
Your
in the
Honor-
declaration, and if it becomes an issue, we get into it further. Did you need to make that an
I did, Your
important
Honor.
part of your case?
Yes.
As the city? How does it relate to your case of an alleged violation of the code?
This is Deputy Durant's observation of Ms. Gish. Her defense is that because she had an injury to her torso, that she could not receive the massage herself. It goes to her defense, and because of her claimed injury.
Let's stop right there.
Yes.
I don't follow that. Isn't the issue the city's raised that there was an employee that was giving a massage without a license?
That's correct.
So how does the condition of the appellant have anything to do with that whatsoever?
It is one of our arguments for not violating and allowing Ms. Lin, who.
Well, you're missing my point.
Right.
How is that relevant? Was there or was there not an employee who gave a massage? Isn't that your case? Why that happened?
Mm-hmm.
Do you really want to go into depth of why that might have occurred?
I'll-
I can think of a lot of reasons that might have happened.
Right.
Is that where the city would like to go?
I will reserve that for rebuttal then, if that's okay with.
Okay, that's okay with me. I'm not trying to make your case, but I don't see how it's relevant to your alleged violation.
Given the materials that Ms. Gish
I haven't
submitted.
even heard from the appellant yet.
Correct. Okay.
All right.
We'll reserve it for rebuttal.
We're going to reserve it.
Yes.
Okay.
Thank you.
Well, then the objection is sustained, and you may bring that up if needed on rebuttal. But it's 10:15. We've got witnesses here. We've got 3 attorneys in the room, plus a hearing officer and city staff. All we've done so far is go through detail of a declaration that's already in front of us. So let's cut to the chase.
Okay.
And get the information. The information's already on record.
Correct.
We don't need to duplicate it
Okay.
by testimony.
All right.
All right? I do want to get to cross-examination and presentation of your other witness.
Okay. Well, then with that said, I have one final question. Deputy Durant, have you tried to contact Ms. Lin since the November 19th incident?
Yes.
And then what happened?
I called the number she gave me, and it went straight to a recorded message from Verizon saying the number's no longer in service. Check your number and try again.
Okay. No further questions.
Okay. Do you have any questions for this witness? And which attorney is representing here for questioning?
I'll be,
Baradon?
yes,
Okay. Do you have questions for this witness?
I do.
Please ask that.
Mr. Deputy Durant, when you entered the facility, what was the atmosphere in the facility?
The atmosphere was quiet. It's
And how did you speak with Ms. Lin, Ms. Gish? I'm sorry.
Well, I just greeted her, said hello. I'm here to do a brief inspection for license renewal.
Okay. Is it possible that you testified that Ms. Gish was very nervous? Is it possible that she was merely startled?
Objection, speculation.
Well, he testified as to her state of mind, which is kind of reaching anyway, in my opinion. So you opened it up. If you open up an area, they can cross-examine on it. Is it possible she may have been startled? That's the question.
I suppose it's possible. She seemed nervous to me, but
Okay, further questions?
And in some of the documents that were presented, you pardon me, withdrawn. When you observed the people leaving the massage therapy room, in one document, it indicates that that the man left first, and in another document, it indicates that the woman left first. Do you have a clear recollection of that moment?
Are you referring to the massage room itself? They came out together. They came out at the same time. I believe he came out directly in front of her. I don't recall exactly. I remember seeing them standing outside the massage room at the end of the hallway together. And then he walked to the front of the business, and she made brief eye contact with Miss Gish and turned around and went to the back, and I called out to her, "Ma'am, come here," kind of thing.
All right. Thank you. No further questions.
Okay, do you need to do any redirect?
Nothing further.
Then that completes the presentation by witness. Thank you, officer, for being here today. And do you have another witness you would like to call?
I do. Chief Souther.
I can get him.
Okay, great. Thank you.
I'll be down in just a moment.
Thank you for doing that. I'm going to help focus this hearing while we're retrieving the next witness on behalf of the city. This is an alleged civil violation, and there's no alleged criminal activity. Is that correct, Mr. Kang?
That's correct.
Okay, I'm not interested then in intent or state of mind. I'm interested in facts. And I will not use this proceeding to try to establish any criminal case against this appellant.
Understood.
And you haven't done that so far, but I'm aware of the opportunity and possibility of that occurring.
Understood, Your Honor.
But that's not why we're here.
Right.
Okay. Looks like your other witness is ready.
Thank you.
Would you like to call your witness at this time?
The City of Kenmore calls Chief Clifford Souther.
Good morning, sir.
Good morning.
Do you swear to tell truth and testimony you give today?
I do.
Thank you.
Good morning, Chief Souther. Please identify your name for the record.
My name is Clifford Sether.
Okay. And what is your current occupation?
I'm a sergeant with the King County Sheriff's Office and have been assigned to the City of Kenmore as a contract city chief.
And what sort of training did you go through to become the chief?
Well, it's kind of, the training I had was training to be a police officer, and then when I became sergeant, I went through leadership training and the additional sergeant type training. But there hasn't been any additional specific training for contract city chiefs. It's kind of, you learn as you go.
Okay, understood. My questions to you are brief and touches upon the Kenmore City Code, Section 5.45. Are you familiar with this code section?
I am.
Okay. And how are you familiar with this code section?
Well, I've been the police chief since the date of incorporation, since August 1st, 1998. So I played a big role in the initial drafting and working with the city attorney and the city council on all the city ordinances in relation to public safety.
Okay, so you're part of, I don't want to speak for you, but you were part of the process to implement this code section?
Yes, I was part of working with the city attorney and the city council in implementing this ordinance, yes.
Okay.
That's correct.
Can you speak about the purpose of this section 5.45?
Well, the purpose is for transparency for massage license, or for massage businesses and massage practitioners licenses, to prevent the prostitution or any illegal activities that might occur at these locations.
Okay. And what sort of, I guess, reasoning, what sort of community benefit, if I can say, was behind implementing this section?
Well, the reason is for the protection of the public in relation to Department of Health codes, and to protect the public from being subjected to any crimes of moral turpitude or dishonesty.
What is the nature of your objection?
My objection is that this is, the chief is going into criminal purposes, and this is a civil matter.
Okay, the question that you're objecting to is about the intent of adopting the chapter of this code?
And the direction in which this is being taken.
Okay. Well, let's keep it on track about the civil violation. Okay. I don't think we have anyone calling into question the constitutionality of this chapter or whether it's been properly adopted by the council. We're really only looking at application, I believe, is it just one section of this code now that we're looking at?
Well, they all kind of intermingle.
Okay, I misspoke, not one section, but one alleged violation.
There are actually two. We revoked her massage business license and massage practitioner's license. So there are two issues at hand.
Okay, I'll let you continue with your questioning, but
Okay.
we'll keep it focused on the alleged violations.
Okay.
Please continue.
Thank you. Are you aware of King County Municipal Code Section 5.445.110, subsection A1?
Yes, I am.
Okay. And what is your interpretation of that section?
Well, that section basically says that anybody providing a massage in a massage business is required to have the proper license.
Okay. And does it matter if the person is an employee or a contractor or a front desk person?
It just says anyone given a massage in a massage business is required to be licensed.
Okay. And are you aware of King County Municipal Code Section 5.45.120, subsection A1?
It's actually Kenmore Municipal Code. I keep saying King County.
Oh, I'm sorry. My mistake. Kenmore.
Okay.
Thank you. It's okay. My mistake.
We'll have, since we're in Kenmore, we'll
Yeah.
do this to Kenmore.
Appreciate that.
Could you repeat your question, please?
Are you aware of Section 5.45.120, subsection A1?
I am.
Okay. In your opinion, why is the city allowed to revoke or suspend one's business license if they allow someone without a license to perform massages?
Well, this goes back to the public safety issue in relation to health codes and criminal activity that might be aloof.
Okay. And another similar question, are you aware of Kenmore Municipal Code Section 5.45.120, subsection B?
Yes.
And then, in your opinion, why is the city allowed to revoke or suspend one's massage practitioner's license if they own a massage business and allow someone without a license to perform the massages?
Well, again, it's a public safety issue. It's to prevent any illegal activities going on and to make sure that, health and safety codes are applied. And
Okay. No further questions.
Okay, do you have any questions on
questions.
cross-examination?
No questions.
No questions. Thank you, Chief,
Okay.
for being here this morning.
Okay, you're welcome.
You are now excused. Does the city have any additional witnesses that you'd like to present?
No, Your Honor.
Okay, so that concludes the presentations of the city's case, and now we turn to the appellant and allow you to present witnesses in response to the city's case. If you'd like, you can give a brief opening statement and then present witnesses, or you can reserve that statement.
I'd like to reserve that statement. I would at this time also would like to object to the city's Exhibit C7. The city has not, this is a copy of a Ms. Gish's massage practitioner license application with handwriting on it that was not testified to and that alleges criminal activity.
Which exhibit?
C7, I believe it is. It's the one that has deny cancel written across the top.
I see it now. Yeah, it's a little tricky because the city never presented this document, is your
Right.
point.
But it's
and you don't want it to be part of this record.
I don't want it to be part of the record.
Okay, Mr. Kang, do you have any response to that?
Your Honor, it's a self-authenticating business record and a public record as well.
Your Honor, I would say that without the handwriting on it, it would be a self-authenticating business record. The handwriting makes allegations that a person ran out of the office. That testimony was not to the person running out of the office, and that is listed as proof of suspicion of prostitution, and that's a very serious charge that the city has not made.
Mm-hmm. Yeah, I am concerned about that as well.
We would be willing to stipulate that the city denied her and canceled her license if that solves the problem.
Mm-hmm. What was the purpose of submitting this document into this record for admission into this record?
It was merely to show that the license was revoked at the time.
Okay. Well, then that meets the city's need.
Correct.
With the agreement that you did I guess revoke or deny, does it matter to you what word is used?
When the notice and order, it was revoke. So
I believe that the city's exhibit C4 meets the evidence requirements for the stipulation, which is the city's order denying the renewal and revoking the business license.
The C4 is the letter of December 1,
Yes.
signed by the city manager. Mm-hmm. Do you agree, Mr. Kang?
yeah, I agree, Your Honor. Yes.
Okay. All right, so we are going to not admit C7 into this record and should not be part of this record, and I will not consider C7. And because of the existence of C4, we don't need the stipulation. We just note that the city did, I'm still not sure what word to use. This says denial. C7 has cancel and deny, and you're using the word revoke. Can the city give me one word that you think captures the action of the city?
Well, I guess to be completely clear, it is a denial of the business license renewal and then a revocation of the massage practitioner's license due to the events in question.
Okay, thank you. Any other objections to any documents of the city?
No, Your Honor.
Okay, then we're ready to proceed with any witnesses you'd like to call.
The appellant calls Mrs. Gish.
Good morning to you. Please raise your hand. Do you swear to tell truth in testimony you give today?
Yes.
Thank you very much. Please be seated.
Good morning, Ms. Gish. Can you state your name for the record?
Yes, my name is Xiao L. Gish. Xiao spelled like Xiao, and Gish is my last name, spelled like Gish.
Thank you. And how long have you had a massage license, Ms. Gish?
Since February 2013.
And when did you open your business here in the city of Kenmore?
It's in May 5th and 2013.
Thank you. And why did you open a business in the city of Kenmore?
Because Kenmore has a very good environment. I still love it very much. It has outdoor environment like Gil Bergman, trail, and the St. Edmund Park, and a lot of people do running, walking, and a lot of outdoor environment. And so I do pretty much those sports massage to help people loosen up their muscles. And I also do lots of therapeutic when they damage their muscle, and it sometimes can be chronic ones. I have those too. So that will use the most of my skill. And also, one other thing I like Kenmore is I have several times I forgot to lock my door there. It's always safe. People are nice. Clients are always nice, and they always appreciate, my massages. Oh, I feel so much better when I work on their neck, and mostly neck and the lower back, and sometimes hands too, because some clients of mine can come from Kirkland and those IT, IT people, they got really bad, and they came all the way here. I said, you probably passed 10 parlors here, you come to here. It's, yeah, no problem.
Could I make one request?
The microphone a little closer.
Okay.
Maybe the whole.
Okay.
There.
Thank you.
Thank you.
Okay, I'm going to take you to the day that you had an inspection, and I'd like you to talk to me about exactly what happened. First of all, I'd like to, well, No, I'd like to talk to you about exactly what happened that day. So can you describe what happened from the time that the officer came into your shop?
Yeah, that was November 19th, I believe, and it's Thursday, because we had a 2 days power cut, no power outage, and then this is day, and I was one of here and don't have electricity, and then came back, I have to work. And so that day, and I got my here, because I get massage.
Let's just keep it to what actually happened.
So then that was like around noon time, and I had another person working there because I got some injuries here, which I have proof, I can tell. And so he worked, that's a client, he called. I said, okay, can you try this person? Because, I didn't tell him I have this. So she's working, and the officer came in, and I was like, oh, never have this happen. So I was like,
And what happened when the officer came in?
So because he came in, he's fast, he's talking loud compared to our environment, because we always keep it very quiet, no sound except the very low background music to kind of relax people so their muscles relax. It's very quiet. It's about the end of the session. So especially end of session, they get all time massage. They got all time for massage. They're a little tired because there's a muscle manipulation. So and all of a sudden talking loud. I never had this kind of a loud talk, or I won't allow this loud talk in the room. So I was like, oh, but it's an officer. If it's a client or someone, they could talk loud, I would say, but I know he must have duty, to be here. So I feel very confused. And I also feel confused. What's going on? I just feel,
okay.
And because I had a very busy day that day,
Okay. And can you describe how the massage areas are separated from the reception?
Yeah, I have, it's a rectangular, area. On one side, there's 3 rooms, and 2 rooms are the massage workroom, and at the lobby area, front area, that's the office part where I do my computer thing and stuff. And on the other side, there's one big room that's facing the door.
Mm-hmm. Okay, and do the walls go all the way to the ceiling?
No, the walls is not going all the way towards the ceiling. It's like 1.5 feet away from the ceiling.
Okay, so people in the massage room can hear what's happening in the reception, and people in the reception can hear what's happening in the massage room?
Yeah, so we, sometimes I can hear outside if I'm working. It's just like almost one area,
Okay.
It's all open there.
Okay. So when the officer, when you told the officer that there was a massage going on, what happened then?
He like he said, he looked at, the front, and then he was trying to go. But I said, massage is about to finish. Then he tried to go in, like he just said, Officer Duran.
Okay. So how would you describe what happened next?
Then I was at the door, so I can see the hallway, and of course I was still in the front. I was just by the office part, and I saw Miss Lin came out. That's always that way, because when a session's finished, we came out with use the towels. We use hot towels to clean the oil stuff, and then the laundry basket is in the back room. So I'm that way, I don't know, 100,000 times. So you do it, then you go to back and drop the drop the hot towel. So.
Okay. And when did the officer follow Ms. Lynn?
I don't get one officer set here because it's been so long. I understand, but as far as I remember, I told officer, let me take care of the client because he's an older senior citizen, so then I'll be right. It's just a minute or so. It's not like so then because when the client get dressed and then he walked it separately. It's not they came together. No, the girl dropped and then that gives the time for the client to get dressed, and then he came out. The client came out to the front desk and and he was a little bit disturbed and feel a little bit uncomfortable. So he paid and then left.
Okay.
And so I explained to him, but I was facing the front. When I was there, officer is right next to me on the inside side, and the client is on my this side. I'm in the middle. So when I talked, I was facing that away from officer. So I said, sorry, but this is just an annual inspection that the city does. It's just a duty. So then when I finished talking, when I saw the client off, then I turned around and the officer said, now I can help you. So then we both walked from the front lobby area or reception area, and then we walked. So I was first, and he followed me. So we went first because we always after finishing we go wash hand. That's the rule too. So then I went to the washing hand place. I also it passed the bathroom. I just look.
Okay, so the officer has said that you told him that you were training Ms. Lynn. Were you training Ms. Lynn?
No, because training is a big word. Because training takes a long time. It's you can't train, and so I was just supervising, especially in my massage. That's why the wall is like that. It's convenient for me. I can hear, and
why were you supervising her?
Because it's my area. I have to be there, and I know I'm responsible.
But why was she giving a massage?
Because I got a little bit here, and before he came, I checked her, the qualification thing. She has 500 hours in the training and education, because and she also showed me her, massage license, which later I know in California it's called a therapist, and there's another less education one called practitioner. That's other state.
And what is your understanding about a massage therapist license from California in terms of bringing it into Washington?
I thought it's just she qualifies 500 hours. Our state license qualified education. You got to have 500 or over hours education. And so I said, that qualifies that. And I said, you got to ask it because I need massage quickly. So I said, how long? It says, it just changed. I said, okay, if it just change it, no need for like classes or hours and something more education. So I said, okay, but I'm waiting for this. You got to, this is missing. I mean, you should have a Washington's, massage license. But I see your qualifications very close, qualifications.
So you had not hired her without her Washington license?
No, it's just helping me to get better. So I just took just probably a couple days when I feel, because same time I was doing stretching a yoga class here. I recently found in Kenmore. Okay. And that helped me too. So.
Okay. So um,
And my instructor in yoga class can prove that I had this issue.
That's fine. So you weren't training her, and she wasn't an employee.
No.
And was this some kind of qualification for becoming an employee after she received her license?
Yeah, I said after license, then we can talk, but not till after, not before.
Okay. No further questions.
Okay, Mr. Kang, do you have any questions for Ms. Gish?
I do. Thank you, Your Honor. Okay. Good morning, Ms. Gish. In your materials that you submitted, you didn't produce any contracts with Ms. Lin, correct?
Yes, that's verbal, because I planned for a couple of days and,
Okay. In your declaration, you said that Ms. Lin worked, and I quote, solely as an office assistant. If that's the case, then why was she performing massages?
Like I just said, when she came, I just tried to make her, it's like a reserve potential for future. So once she get a license, I was looking at the future. The premise is always very hard to find a good, good therapist or practitioner licensed.
Okay.
So I got a lot of miscellaneous things to do too. Yeah, so assist me if I'm working, and she got to take care of other things.
Okay. And one of the reasons you mentioned in your testimony and your affidavit is you had an injury to your torso, which is why she was doing the massage, correct?
Yeah, it's pain.
Okay.
Yeah, it's
but
pain.
you didn't produce any medical documents in your material showing any injuries, correct?
Well, I didn't know that's
Yes.
a issue or anything,
Okay.
I can't. That's why I have phone number and the instructor. Instructor's name is Vido Biden, and it's Lakeview yoga place,
And then you also indicated that because of your injuries, you had someone else, you had Ms. Lin provide massage to another person, but you didn't include any reports or any assessments from this person about Ms. Lin's skills in your materials, correct?
Say it again.
In your affidavit and your testimony, you said that because of your injuries, you could not receive the massage yourself, so you had someone else receive the massage to assess her skills, correct?
Yes, to give me feedback.
Right, but you didn't include any feedback in your materials, that's correct?
I thought I ruled on this already. You're sitting there silent, but you earlier objected to this line of questioning. Have you changed your mind on that?
No, I continue to object.
Well, please pay attention then, because the condition of Ms. Gish's torso or back or whatever, that's not an issue before us here today. We didn't go into that earlier. You did reserve it, you said, as rebuttal. But I didn't hear any questions on direct going into that.
She spoke
condition.
about her torso and her injuries. It was in her testimony, Your Honor.
Did she speak to it in her testimony? Is that testimony you elicited from her?
It's not in her testimony today. It's in the
affidavit or the statement.
Right.
We can have the recording heard back. I distinctly made notes, Your Honor. They opened the door to this line of questioning.
Well, let me ask you again. Why is this important to the city, to establish the physical condition of the appellant?
It goes into their argument why they did not breach the code, and why she has someone else do the massages, and why that's justified.
Well, let me state again, I don't find that at all relevant as an excuse or justification. You know, the question goes to the two alleged violations that are in the letter. That's what establishes the scope of this hearing. Would you agree with that, Mr. Kang?
I agree.
Okay. And one is that someone gave a massage without a license. I don't think that's this individual. It's not Ms. Gish, is it? Did she give a massage without a license?
No, she didn't. However...
Okay. All right. No, just stay with me.
Okay.
The other allegation is that she allowed someone on her business premises
Correct.
to give a massage without a license.
Correct.
Right?
Correct.
That's all I'm interested in. Why she might have done that, whether it's her friend or relative or because she has a problem with her own back, tell me how that's relevant. I know that the appellate maybe had stated, well, I had her give a massage to someone else because of my physical condition, but why is that relevant to the alleged violation? Is there something in your code that says if you can't take the massage yourself, it's okay if an unlicensed massage practitioner gives a massage to someone else?
No.
Is that in your code?
No.
Then I ask again, what are you trying to establish with this?
Okay. Well, I'm trying to address their defense.
Well, let me ask the appellant then. Is your defense to this that your client could not receive a massage?
Our primary defense, no, that is not our primary defense.
Okay, is it part of your defense that she could not receive a massage?
It was part of the explanation, but Your Honor has decided that that's not relevant, so...
Well, and do you disagree with that? Why is it relevant whether or not she could receive a massage?
The only relevance was as background explanation for why Ms. Lynn was not an employee under the Kenmore's code that applied to persons hired.
Ms. Lynn was not an employee because she was giving a massage to someone else only because Ms. Gish could not receive the massage.
And she had not been hired to give massage. And this was not a pattern or practice. It was explanatory.
Well, may I ask your client that question?
You may ask my client that.
Did you hire Ms. Lynn? Did you pay Ms. Lynn to give a massage?
I didn't hire her.
Did you have any money that you gave to Ms. Lynn for the massage?
Some compensation.
Some compensation.
Mm-hmm.
You did give some compensation.
My understanding was that the compensation was for other duties as an assistant, things such as bringing towels, answering the phones, doing laundry, that type of thing.
Yet,
So,
Ms. Lynn did give the massage at the direction of.
yes, she did.
Okay. Well, City Attorney Kang, I think that's all you need.
I think I'm done, Your Honor.
Isn't that right?
That's correct.
Okay. So thank you for clarifying. Now, do you have other cross-examination questions?
I'm done at this point.
Do you have any redirect?
Not at this point.
Okay, because I've got a lot of questions of the attorneys here. Thank you for your testimony.
Thank
you may
you, Your Honor.
leave the witness stand. All right, and I'm cognizant that the three attorneys here in front of me likely do not practice often in the area of hearing examiner appeals for code violations. Is that a correct assumption?
That's a correct assumption.
Okay. So I want to get us all helping each other, because I've got to make a decision, and I want to make the right decision. I want to make one that's fair to the city and fair to your client. And I have to do that based on facts, and I think you brought those forward. They weren't any different than what was in the declarations, but you each had a chance to cross-examine, and I don't think we punched holes in anybody's statements before the hearing. We know what happened. The questions that I have to answer that are more challenging are ones related to law. And so I want to ask each of you to help me understand the law. And maybe you're going to do that in a closing statement. I don't want to preempt if that's where you think you're going. But I need more information than what I have. I appreciate you each did a brief, and that's my first area of inquiry. I heard nothing from the appellant's counsel about this, but I have to say I am concerned at what we have defining the scope. And I've done hundreds of these hearings, so in many different jurisdictions. Each code's a little different, but I think there are some things in common. The first thing in common is that the scope of the hearing is set by the letter of denial and revocation. Any disagreement with that? Mr. Kang said no. Do you agree with that as well? And Ms. Don agrees with that by nod of head. Well, if we look at that exhibit, we looked at it earlier, and it's Exhibit C4. And I have to make some assumptions here. I'm going to ask Mr. Kang to help me. In C4, in the first and second paragraphs, there are references to the Kenmore Municipal Code related to the alleged violations. And the first one we see in paragraph 1 is a reference to inspection. That's not relevant to the alleged violation. That's just how they got on the premises. And nobody brought that up, that he was there inappropriately. So good, we don't have to deal with that. Now, the next sentence, the result of the inspection revealed that a person who did not have a massage practitioner license was giving a massage to a customer in violation of KMC 5.45110 sub 1. Now, of course, that doesn't exist.
It should be sub A1.
See how that helps me? I don't know what the city's alleging. I had to make an assumption, and I shouldn't do that. So that, that often is a challenge in front of me, that the wrong citation was given, because part of the due process that has been referred to by appellant, and the city has done a nice job of defining due process in your brief, but you need to know what you're alleged to be in violation of. Since the appellant didn't bring it up, I'm not going to go there, but I could have, had you brought it up. It's the wrong citation.
We did raise it in our brief, but we didn't raise it today.
But not here today, and if it's not raised, I have to consider it might be dropped, because I need to know what you're pursuing. So we're going to let that one go. But then the next one is 545030 sub B, unlawful for any person to give a massage without a massage practitioner license. Mm-hmm. Okay? And I want to ask the city attorney again, I understand its relation to standards of conduct, but it's not the city's intent to suggest that Ms. Gish is in violation of giving a massage without a license. Is that correct?
That's correct, Your Honor.
She did not?
She did not.
Yeah. Okay.
I think the assumption was it was allowed to occur in her business, and then after that, as you alluded to, it leads to the other chain of code violations.
Okay. But you see how that might be misread when we look at the letter.
Correct, Your Honor.
And I understand this too, and it's a challenge for any city attorney. I doubt if they ask you to craft this letter. This letter was written without your involvement, and then you're here having to proceed even though you didn't write the letter. That's a challenge. And in some cities, the city attorney is involved in drafting the letter of violation. Now, if I continue to look at the materials, what I don't see in this letter of violation, which we might call C4, letter of revocation because of alleged violations, I don't see a reference to what we just talked about, the failure to comply with application standards of conduct. Is that in this letter? Did I just miss seeing that? Because that reference in your brief is 545120A1B.
That's correct, Your Honor. It's not in the notice and order. It is in our brief materials.
And again, the appellant didn't raise this, so I'm a bit on thin ice going where I'm going, but I'm charged with writing up a decision on this. And maybe, Mr. King, you can explain to me how that alleged violation can be defended against if it's not in the initial letter. You follow my reasoning on that? And the reason I'm bringing it up with you is because fundamentally, the thing I always need to do when I come into a hearing room is to ensure that procedural due process is followed. And I appreciate how you addressed it in your brief, as did the appellant. So that is in front of us. Was due process followed? And to my way of thinking, it's fundamental to due process in a code violation hearing that the alleged violations are set forth in a specific letter. And here's my concern. If I go to that section of the code, 54512A1B, fail to comply with standards, I'm vulnerable to being overturned because I only see it in your brief. And that's what I want to be clear if I missed something. Do you follow my line of reasoning on that?
I do, Your Honor. I understand your situation. The document speaks for itself. I understand that. And the first time the repercussion sections of the code was referred to, that, to my knowledge, is our brief.
Yeah. And I don't think you're out of line to do that. I think it's something you should do. Appellant's counsel should pick up on that. But that's why I asked earlier, what are the alleged violations? Are they set forth in C4? And you as city attorney agreed, yes, they are. And that section's not in C4. Now, you still have other alleged violations, right. That an employee was giving a massage without a license.
Right.
And I don't know if you need this section to get to denial or revocation, because you're allowed to deny a business license if there's been a violation of the code, correct?
Perhaps, yes, Your Honor.
Okay. So, and I'm not trying to signal where I'm going with writing. It's just, man, I was hoping for a lot more from the attorneys than I got this morning. Now you're helping me understand that. Then I need to take a note here about what we just discussed. And it is a challenge if this section 545120A1B is not in the letter denying. Does that give sufficient notice to the appellant to be able to appeal? And I suppose that could be debated. But here the city, as just discussed by city attorney, put it in the brief for the first time, and I'm loath to go to that as in a violation, and for other reasons too, because you have already set forth the allowing a non-employee to give a massage, and that stands alone without needing to go to 545120A1B. I'll give you each a chance to think about that too, as I have other questions, but I want to come to a understanding of law on this. You may disagree with my understanding, and that's why I want to give you an opportunity to put on the record your disagreement. Okay, anyone have anything further to add on that?
I would simply add that the appellant's brief did not discuss 545.120A1B because it was not in that letter.
Okay.
Your Honor, if I may, I'm looking at Kenmore City Code 5.05.130, which refers to the notice and order itself. It is, and in there, subsection 2, and I'll read it for the record if that's okay, it states the notice and order must include, and I quote now, a statement that the city manager has found the conduct of the person to be in violation of this title, with a brief and concise description of the conditions found to render such person in violation of this title. There's no requirement that the actual code needs to be mentioned.
Okay, what section is that again?
I'm sorry, Your Honor. It is 5.05.
Oh, 505.
Yes, 05 is the general rules. 5.05.130.
Okay, this is the requirements
For the notice and order.
what must be in a notice and order. Okay, I appreciate that.
There is no requirement for a specific code to be inserted. The conduct has been described in the letter, the notice and order in C4, so we argue that it meets the requirements.
A brief and concise description of the conditions. Is that what you're referencing that in particular?
Yes, Your Honor.
Because there's no doubt that C4 says you're found in violation of the title 5.45. The question is a brief and concise description. And I think it's an appropriate reference. However, in this case, there isn't a brief and concise description that the standards were violated, and therefore there's a denial. But I'll take that into account. I think you put anything you wanted to say about that?
I would think that if the city's going to rely on a particular section of code, then they need to set that out in its brief and concise description.
Okay, so we've looked at that one, and another area I want to look at with the city is we raised this earlier, revocation or denial. And I'm looking at the facts that you put into evidence, where we have a practitioner license held by Ms. Gish, and that's the reference to MP 14-227.
Okay.
And she held that from November 3rd, 2014 to November 13th, 2015. And her renewal application came in on October 29th, 2015. Those are facts that are here in evidence. Here's what I want to get to. The notice and order, Exhibit C4, states the city denied your license renewal request and revoked license BL 14225 and MP 227. Revoked it. That's a December 1st decision denying renewal applications, and then 2 licenses which expired on their own accord on November 13th. That's what I'm trying to get to is how can it be revoked if they expire? You follow my question?
I do, yes.
And I asked this of Mr. Kang because you've impressed me how familiar you are with the city's actions. And again, that's a challenge. You come in as the attorney, you've got a couple of officers, a city manager, you try to piece together what happened. And you may be hearing this question for the first time. But looking closely at what you've submitted, when we look at those dates, the investigation occurred on November 19th. That was discussed today. And then this letter comes out on December 1st. But the licenses had already expired. So can there be a revocation if they're already expired?
One would think no, Your Honor.
Yeah, and you see what I'm trying to do. This is for my own good. I'm trying to simplify what I need to write up. And if it appears that that's what happened, because of the sequence of events set into action, where there wasn't an opportunity for a renewal to occur, and in the meantime, they weren't acted on, so they expired. And that's, I think we can note that, because I didn't see anything in the record from the city where there was other than the C4, there wasn't, revoke this. You felt like you had, on that one that we didn't admit, we had handwritten notes about cancel or deny. And I would think if there's a revocation, there would have been some action by the agency to say revoke, but rather it expired.
Correct.
Okay. Anything you want to say about that, Appellant's Counsel?
Well, we found it troubling as well because it appeared that the only reason for the expiration was the city's late inspection. There was no question until the officer walked into the facility for the inspection. Ms. Gish had been renewed before and in fact has told us that she was not inspected prior. So we were somewhat confused how you could revoke a license at that point.
Well, we have, what do we have, 3 different licenses here?
There are 2 licenses.
Yeah, I'm not sure what the reference is to, so the MP is the massage practitioner license.
Right, and the
We've got the business license.
Right.
What's that other one reference? The
it may be her state license. The issue here does not address her state license.
Yeah. Oh, it's in C4, that exhibit, the letter.
Let's see.
Revoke license BL 14226. That's the business license. That's
the business license. And
so,
MP 14227 is her personal practitioner license.
Okay. So there's 2, as you said, 2 licenses. And maybe the confusion for me is that second paragraph of C4, quote, this letter is to inform you that the City of Kenmore has denied your license renewal request and revoked license BL 14226, which is the same. As right, Mr. King, maybe you can help here. And I know you didn't draft this. I really empathizing with your role, but it seems that second paragraph says we've denied it and revoked it.
Correct.
All right, and we got to settle on one. And I think earlier we talked about this, and it was denied. The renewal was denied.
I agree with you. Yes.
Yeah. Okay. But and the other reference to massage practitioner 14227. That's the point you're making. It basically expired.
Both of them had expired,
okay.
and she had and it's in evidence
well,
that
well,
she
hold
had.
on though, because it's awkward because it's not in front of us, and we agreed that C4 would serve that purpose. You mentioned earlier we can stipulate the city denied the business license. Remember that
Right.
We got there because they wrote on it cancel or deny.
Right.
There was action taken by the city on that application. I don't have anything similar for the massage practitioner renewal.
We have an exhibit. Let's see, which one? We have a one moment. Let me. I apologize for being a little slow here.
Well, no, they're not issues you put out before me today, but man, I'll tell you, when I got to write it up, I've got to address these issues.
Our Exhibit A3 shows the application for the renewal of both licenses on October 29th.
Right, so this is the one that looks like a spreadsheet.
Right.
Yeah, and it shows in handwriting that they were
Right,
paid for.
and it was signed as received by, and we would certainly stipulate that that would come.
Okay, and that's the application
That's the application.
for the massage practitioner
Right.
license.
And Ms. Gish did not receive anything from the city until she received this letter.
And in the meantime, it had expired.
Right.
So that was my question earlier. How can it be revoked if it actually expired?
And I don't know that Ms. Gish knew the standing of her license at that time, since she had timely applied.
And then if you look at C8, the city's materials, it shows her application for business license was received by the city on October 29th as well. So both were received the same day.
And that's where I was going, is that, one, you agreed, and we have some evidence that's not really part of the record, but the city actually took action on it.
Correct.
On the business license application. But, they wrote on it, and that was separate from the letter. On the massage practitioner license application, there's no indication of action by the city at the administrative level. I don't know if that's important, but that's how the facts line up. Mm-hmm. And that also assists me, because I will find that the city denied the business license, but I was very concerned about whether I find that they revoked the massage practitioner or just it expired. And I think it expired before this letter came out.
Yes. The appellants are concerned about the basis on which the city claimed to have revoked the personal license, her massage practitioner license.
Well, that's why I'm inquiring about this, because I didn't even know if that was in front of me. It was primarily the business license denial.
Well,
but is it also an issue about?
It is also we understand the letter to say that they revoked her personal massage practitioner license as well, despite the technicality of both licenses having expired before the letter came out. And we're very concerned because it appears that the denial of her personal massage practitioner license was based on 545.030 sub B, which is the prohibition on performing a massage without a license, and there is no evidence that she did that. All of the allegations relate to the business and running the business, not her personal massage.
Well, that's exactly why I'm suggesting the direction that I would take is that if it expired, then your client could apply for that massage practitioner license again. If it's revoked, then there would be some hurdle to clear. I don't know what that is.
There's an additional appeal if it's revoked. Yeah.
But when could, if you did deny a license, when can one apply again?
I believe it's 3 years.
It's a 3-year
Yes.
hiatus.
That's my belief, Your Honor.
And does that apply to both the massage practitioner license and a business license?
My personal recollection, I believe that's true.
In what would that be in chapter?
That would be in 5.45, actually. I think 050 speaks to the denial of license.
Let's see if we can find that.
Okay. I believe it's 5.45.050, Section 2. The city manager may deny any massage business license, and so on. And within 3 years prior to the date of the application,
Yeah, looks like you're in the right area.
yeah.
And there it is, sub B, heading massage
Correct.
business license, denied or revoked.
Oh, the effect of license denial, I'm sorry. That would be C, all the way at the bottom there. If any applicant has a license denied, a license may not be granted within 3 years from the date of such denial.
Okay.
Yeah, there you go.
Provided such denial was based on a conviction classified as a felony.
Right. And 545120 sub capital C, the effective license revocation is that if any applicant under this chapter has a license revoked, the license shall not be granted for this chapter for a period of at least 1 year.
And right after that sentence that I provided, all other convictions of this chapter will preclude the issuance of license for a period of at least 1 year from the date of such denial. So I think it's 1 year is what we're looking at.
Yeah.
But conviction would refer to a criminal matter.
Of this chapter? So,
Well, it's an odd choice. I don't think this city attorney was not involved in drafting this code.
No, I was not. I was not, Your Honor.
So, yeah, there are challenges with this code.
Right.
And we're not going to resolve them all today.
I only mention that because this code does include penalties around prostitution and those things, which would be
Well, the position you've
related.
taken today on behalf of your client is she did not give a massage without a license, and the
Right.
city agrees with that. She applied for renewal of her massage practitioner license, and it doesn't appear it was acted on by the city. And there is some language about the city shall act within 4 weeks.
Right.
And therefore, where I'm going is that it expired. And if it expired, not revoked, it then allows her to reapply for her massage practitioner license. That's different than the business license. But I think that's consistent with where we're all coming out, looking more closely at the code.
yes.
And it certainly makes it a cleaner write-up for me to do that. So unless there's some vigorous objection, that's the direction I think I will take. Okay. Don't be concerned. I think I'm getting to the bottom of the issues. I may have one more. And, you know, as we go through this code together, I'll just note, and I'm sure you're both seeing that as well, all three of you, that suspend is used, revoked is used, denied is used. It's a messy code.
Yeah,
Right.
And you can share with your client, Mr. Kang, that this hearing examiner is troubled by this code. I didn't want to bring that up in front of the chief, who apparently had some involvement in preparing it.
Right.
But I don't know for sure when it was adopted. It looks like it references 1998, maybe amended just last year.
I believe that's correct. See the ordinance 2015. I believe that was in July of last year.
Yeah, but you might want to take a look at the issues we're touching on today.
Right.
And I will do my decision, and it might help too, in terms of what needs to be clarified in the code. So if we have other items come before us, we have some clarity from the council.
Thank you.
That's one thing I'm noticing is suspend, revoke, denied, and they have different consequences.
Mm-hmm.
Absolutely.
Okay.
And we had considered that those were different penalties, as they often are in administrative matters. That, for example, I've dealt with other matters where a license was suspended and a suspension was stayed, and pending things, but. And here the city just, in the letter, just went straight to a revocation.
Well, update me on that. What happened? Because that was a preliminary matter where I think the appellant's counsel said unfair to stop the business practice, and then in your own code it appeared that if there's an appeal, there is a stay.
Mm-hmm.
How is the business operating today?
It has been up until today. We were unclear what would be. It is Ms. Gish's only source of income.
Mm-hmm.
I think it was clear from her testimony today that she was somewhat confused, and I recognize that lack of knowledge of the law is not an excuse, but there is somewhat of a language barrier where a person reading the code and seeing the word employee might be legitimately confused.
Yeah, and I'll address that in my write-up and address the issues we just discussed. And that's the final area of inquiry then for the city, is that your request for relief from me, or not relief, your request of me doesn't contain any penalty request? Is it just to uphold the city's denial of business license?
That's correct, Your Honor.
Okay. To uphold the city's denial of business license. So they're not requesting, the city's not requesting any penalty or fine.
Okay.
Is that consistent with your understanding?
That we are not aware of any penalty or fine that's being requested.
Very good.
Although it is within Your Honor's discretion as well. So.
Mm-hmm.
I have that authority under your code. Yeah. Very good. Well, thank you for indulging me and engaging in a dialogue about what does the law say. And we're not going to be able to work out all the details of that, but I appreciate the guidance that you gave me on how you might interpret the code, not only during the presentation of your appeal, but in a somewhat unusual departure following the presentation of the appeal, just to help this lowly hearing officer try to understand what my responsibility will be. I appreciate that we did work out the due process allegations in advance of the hearing, so those are no longer in front of us about stopping the business. So I don't have to speak to that, but I will speak to the denial of the business license and the expiration of the massage practitioner license, and do that in a way that might help suggest a pathway for the city to get on to help clarify its code if there's any actions by the city in the future to deny, revoke, suspend, or otherwise take action. I think we're at the conclusion of the hearing. Are there any final comments or thoughts of any of the legal counsel?
I would. Do you have any?
Oh, no, nothing from me. Thank you.
Because we've covered most of what I would have covered in a close, I only would say that I would draw your Honor's attention to 545-130 sub B, where it provides you with the opportunity to I'm sorry, I changed my...
What's the reference?
545-130 sub B. I need to get back to it and give you the...
Let me see if I can find it.
It allows the hearing officer, in addition to or as an alternative to any penalty provided herein, either to assess a civil penalty or any other penalty. So one of the things, particularly as 545-110 allows for revocation or suspension. Ms. Gish, who has not had any problems with the city up until this point, understands the gravity of the situation, would appeal for the mercy of the hearing officer. The city took the most extreme penalty that it could have taken. Ms. Gish is not arguing that there should be no penalty, but would and has in fact offered the city the opportunity to do a stayed suspension of her license, to place a requirement that she have no employees, and or to take some other intermediate step that between cutting her off from her ability to make a living. This is not a situation where an entirely untrained person created a danger to the client. It's not a situation where she had an ongoing practice of having unlicensed persons in her shop. It's not a situation where there was any evidence that there was prostitution or other illegal activity happening. And the city took the most extreme option it could take in that situation. And we believe that there is room for the hearing officer to apply discretion.
Yeah, and your citation is to 130, 545 130B?
B as in boy.
Uh-huh.
And also,
I'm looking at that now. I'm looking for that authority. Can you point to it?
It says, well, it would. This relates specifically to an alternative. There would be a fee.
It seems to relate to what a city manager may do in assessing direct assessment of penalties. In that letter, the city manager could have said the following penalties shall be paid. But there weren't any, so those aren't on appeal.
Right.
And I think this section speaks only to the city manager. That's, I believe, the reference, the city manager.
Right.
I think I do have authority to take other appropriate action, but I don't think it's based on this section.
Okay. Well, and 120 sub A1 does at least, again, it does list the city manager, but it does at least indicate that it could a revocation or suspension. I apologize. I don't have the exact note in front of me.
Of course, it is important to bring the chapter of law.
It is important, and I thought I had all of it with me, and I don't have that one.
Okay, I'm going to have to strike the note I took that 545130B may be appropriate to review, because it doesn't appear to speak to my authority.
Your Honor, may we ask upon which code are you basing your authority for some discretion?
Well, it's in both. 505 is general licensing provisions. There's a chapter dealing with appeals, and then the 545.
Thank you.
All right. I think we've. I believe we've come to a conclusion, but on that last point, Ms. Don, what is it that you believe is an appropriate sanction if there was a violation?
We believe that a stayed suspension with conditions would be an appropriate sanction. We would not object to a more frequent inspection. And we would not object to a condition that she did not have any employees for the period of the suspension.
Did you discuss that with the city prior to the hearing today?
We made that offer to the city.
Okay, that's all I need to know. All right.
Your Honor, if I may, just add
Okay.
one more. I will refer you to, for your assistance, the Civil Violation Appeals Hearing Rules, Chapter 3, and it is Section 3.9.2, the decisions of the hearing examiner. And in the very end, I'll say that again, in Section 3.9.2, subsection C, it provides you with the authority to assess penalties, costs for enforcement, require corrective action, and so on and so forth.
So thank you.
Yeah.
Thank you. Those are the rules of the hearing examiner. I appreciate that you actually reviewed those prior to the hearing. And I do have those in front of me if you haven't seen those. Do you need a copy of those?
You know, I reviewed those. I just didn't bring the hearing examiner's rules with me.
Okay. I think we've concluded this hearing today. I want to thank you, three attorneys, for your participation in the hearing. Thank you, Ms. Gish, for being here today and offering your testimony. I will write up a decision with findings of fact and conclusions of law, and I'll do that within the next 10 days and make sure it's provided directly to you.
Thank you, Your Honor.
We are now adjourned. I'm informed the record is still running until we get, maybe Mr. Kang,
I'll let him know right now.
alert them, and then we'll close down the record. Thank you, sir.
Thank you. Pleasure.
Nice to
Thank
see
you.
you. Nice to meet you.
Thank you.
You didn't have a lot to say, but you were moral support at least. That's always helpful.
It's always good to get experience.
Yes. Good. Okay.